Hello everybody, my name is He Xiaoyun and I'm a doctoral candidate with Indiana University School of Law. My research focus is China's legal system and judicial selection. Before 2004, I was a judge in a provincial high court in People's Republic of China. Thanks to the invitation of Indiana University Kelley School of Business, it is my pleasure to be here to discuss with you China's civil trial system. To understand China's civil trial system is helpful to doing business in China, and also it's important if you want to stay out of trouble. In today's presentation, I'm going to lead you through the whole procedure of filing a lawsuit in China. We are going through from file the case to court trial, from decision making to enforcement of the final judgment. I hope you enjoy the class.
Okay, in today's class, I will introduce to you how to file a civil lawsuit in China. I will give you an overview of China's legal system at first. China's legal system was originally borrowed from the Soviet Union. However, the legal reform from 1980s followed a continental, or we call the civil law system. In China, the trial is governed by civil procedure law and the Supreme People's Court's judicial interpretations. China's court trial system has a hierarchy of two court instances, which means there is one trial and one appeal. The decision of the appellate court is the final decision, and a case is closed after going through two levels of trial. The court system in China is a single system, consists of the Supreme People's Court, high courts, intermediate courts, and basic courts. Let's see the following chart. At the national level, we have the Supreme Court. Supreme Court located in Beijing, and it is single Supreme Court. It is the highest court in the country. In the provincial level, there are high courts. High courts, cases heard by high courts are going to be appealed to the Supreme Court. After that level, we have city or county level intermediate courts. And then the grassroots level, we have basic courts in city districts. This system we can see is different from the United States, where we have a dual legal system. We have the federal court system and the state court system. Each system have their trial court, appellate court, and Supreme Court. So in China, this is a single system. I will introduce each court in more detail. The Supreme People's Court is the highest court in the judicial system of China. The Supreme Court not only hears cases, but also is in charge of the interpretation of laws. For example, the civil procedure law itself has 270 provisions, whereas the judicial interpretation of the Supreme Court to this civil procedure law has 320 provisions. Only 13 cases can be filed to the Supreme Court. The Supreme Court only hears civil disputes involving more than 40 million US dollars. However, the Supreme People's Court overall jurisdiction has two exceptions. Hong Kong and Macau are out of the jurisdiction of the Supreme People's Court. Hong Kong and Macau, as special administrative regions, have their own separate judicial system based on British common law traditions and Portuguese civil law traditions. China has 31 high courts at provincial level. High court accept first instance civil cases based on the amount in controversial. So some high courts hear civil cases involve controversial of more than 40 million US dollars, while some other courts hear cases, first instance cases at more than 7 million US dollars. That's a big difference. This is because of the different level of income or economic condition in those provinces. The courts in the provinces of East Coastal have set up higher adjudicating standard so that they don't need to hear too many cases, and as a result the Supreme People's Court would have to hear more appellate cases from those specific regions. Next, we have intermediate courts. In China, there are totally 390 intermediate courts. Similar to the high courts, intermediate courts accept first instance cases based on the controversial exceed a certain amount of value. According to the civil procedure law, one exception is that all cases involve foreign elements must be heard by intermediate courts. From 2005, Supreme People's Court has launched the pilot project authorized some basic courts to hear foreign-related cases involving small amount. Last level, basic courts. China has 3,000 basic courts hear 80% of all the civil cases. Basic courts hear all civil cases that the amount in controversial does not reach the intermediate court's standard. 76% of Chinese judges work at basic court level. Basic court adjudicated 80% of all cases. Not everybody wants to file lawsuit to a court, so to avoid lawsuit, there are some strategies I want to mention here. First, be careful to fulfill contractual obligations, especially obligations relating to the quality of products. If a contract specifies that the buyer will conduct quality inspections and the buyer fails to do so, it may become more difficult to hold the supplier liable for defects later. The second is the contract should also make clear how disputes will be resolved before the legal stage. If the contract is subject to Chinese law, any independent arbitration should also be done in China. So there is alternative ways to resolve dispute like arbitration, which is also a good choice, like before go to the court. The third strategy is that the United Nations Convention on Contracts for the International Sale of Goods has been ratified by China. This is a very good strategy to use. The convention is now usable within the Chinese legal system, which means this convention's framework may often be as good a choice as Chinese contracts, or even it's better than use the Chinese contracts law because it's more international accepted. It's good to avoid a lawsuit, but sometimes it is necessary to file a lawsuit too. We are heading to the civil lawsuit part of today's class. Here is a map for today's presentation. We have 4 questions we're going to discuss. First, case file and acceptance. Second, trial and judgment. Third, appeal. And fourth, enforcement. Let's move on to case file and acceptance. Who can file a civil case? A citizen, a legal person, or an organization? Where to file this civil lawsuit? To the right court, The right court means a court has jurisdiction over the subject matter of your case. Usually, if you are a foreign company or a foreign citizen, your case shall file to intermediate court. But as we learned before, some basic courts may have jurisdiction over your case. To file a case to the right court is very important because if you want to try to avoid a jurisdiction argument, which is a separate hearing and decision-making process and appellable, it can take longer than several months. The second good thing is can try to avoid local protection, which means the interference from local government. How to file this civil case to a Chinese court? The first step is to prepare a complaint. Second, work with a local lawyer. That is thing I would like to recommend because Chinese court may have their own practice, method, internal rules that local lawyer is really helpful, and we know that foreign lawyers are not allowed to practice law in China. The third step is to submit your complaint to the case acceptance division of the court and then pay the litigation fees. The case acceptance division will review your case, and if the case is accepted, you will be notified of the decision. And then the case acceptance division will pick up the forum members, serve the complaint to the defendant, and decide the trial date and venue. If it is an open trial, usually like cases involving contract law, business law, there should be an open trial. And in case of open trial, the case acceptance division is going to inform the public of the time and venue. Some key points in case filing. First is to file the case to the right court. I will give you an example with a case that I presided over when I was a judge back in China. In 1998, I presided over a contract case that arose from the construction of a building. The building had been completed without a flaw, but the defendant refused to pay the plaintiff the money he owed under the contract. When the plaintiff filed the suit, the defendant responded with a meritless jurisdiction argument, which is a routine strategy to intentionally delay a lawsuit. After 2 months, the motion was denied. The defendant did not appeal immediately. Instead, he took his time strictly according to the civil procedure law, which states that the parties have the right to appeal within 10 days after the received adjudication. The defendant appealed on the 10th day, which is the last day of appeal. The appeal was denied again after a month. After 4 months delay, during which time no information was exchanged between the parties, the case went to trial. At that moment, the plaintiff almost ran bankruptcy. When I asked the defendant's attorney if she think that the jurisdiction argument was necessary, she said, "No, I didn't even know that my client had moved to argue the jurisdiction." This is a real case, my real experience. That's why I think to file a case to the right court is really very important part in the civil case filing procedure. Second, civil procedure law does not impose the defendant the obligation to make response to the complaint, which means if you filed a lawsuit and you did not receive a response from the defendant, that does not mean that the defendant has admitted the fact stated in your complaint. This is totally different system, different rule. In China, there is no such rule that if the defendant does not make a response, it means that's an admission. That's not true in China. If you never receive a response, you have to move on to look for a response at the court trial procedure. So at the court trial, you will finally receive a response from the defendant. That's the case. The third, which is vital to a civil case, is property preservation. This I will talk about this at the civil enforcement part, which is the last part of our case filing procedure. I will talk at a later time. Here, I want you to take a look at the expenses. This is the first column is the amount in controversial. So that's the case you filed. If you file a case asking for, if you file a case for like 1 million in Chinese yuan, that is US dollar. So this is confusing here. Anyway, oh yeah, it's US dollar between 71 to 142,000, and at this amount, the attorney fee would be 1.5% to 2.5%. The court fee, that means the fee you submitted to the court when you file your case, is 1%. So you can do your math here and get an idea how much the court is going to charge for the case. And the attorney fee here, I want to say, it's not a fixed. In China, lawyers can negotiate with their clients to work out, they can work out a contingent fee, and they can also work out a fee payment schedule based on their contract. So that's a different thing. Here the court fee is 1%. Anyway, if it's 1 million Chinese yuan, then the plaintiff must pay 1% at front. Okay, the complaint is filed and served, and next step is the court trial. Be prepared that a trial may not solve all the issues. A trial may be followed by several meetings initiated by the presiding judge. The time to make a decision after the trial is 3 months according to the civil procedure law, which rarely to be true. Most time it takes longer or double. A trial. Trial, when I say trial, that means the court procedure during the trial. So the first step is court investigation. At that time, both parties, plaintiff and defendant, are given time to present their opinions regarding fact and laws. And the second step is court debate. Both parties are going to give their argument, and their lawyers can give their opinion at the same time. And the third step, final statement. Each party can give their final statement to the court. And last step, judgment. Some cases, the judge will give out a judgment immediately follow the court trial. But in most situations, the judge is going to give a judgment, announce a judgment later. The evidence rules. The evidence rules in China is also very unique here. The first is documentary evidence is highly persuasive. Chinese courts rely primarily on documentations rather than on people's testimony. Keeping as much information as possible about business activities in writing will be a powerful aid in any legal actions. Examples of documentary evidence such as a bank statement, a signed contract, a police report. Please note that litigants must provide original copies to the court. Testimony of witness is not that important. Witness is not required to present at the trial. evidence is required to submit it to the court before the trial. Some cases may end up with a settlement. In early 2008, the Supreme People's Court has reported a 30% settlement rate for civil cases. The presiding judge has much incentive to settle a case. Usually, a settled case takes a shorter time, quicker execution. So usually, when a case is settled, the case is going to result in a voluntary performance. And from the judge's personal opinion, it's also beneficial because if a judge settles more cases, then for the annual evaluation of the judge's work performance and or maybe related to bonus, it's helpful. It's going to give this judge more credential if he can settle more cases. But not all the cases can be settled. Most cases need a judgment. Who is involved in making a judgment? The three-judge panel, the presiding judge, the chief judge, president or vice president, or judicial committee. Those are the concepts I want to introduce to you. So in China, the presiding judge is the judge who is in charge, personally in charge of this single case, and then the court trial is going to be conducted by this three-judge panel, include this presiding judge. So the three judges is going to go to the court trial, hear the case together, and they are going to discuss the case and make the decision together. The chief judge is the head of the division. Like usually if it's a civil case, then it's the head of the civil division. Chief judge is in charge of a lot of administrative activities in the division, but also in charge of review those cases when he thinks it's necessary. President or vice president of the court, usually there's one vice president, especially in charge of civil cases. Some, like there is another vice president who is in charge of criminal cases, and then a third vice president who is in charge of civil enforcement. That's the court organization system. And the president is the single one chief of the whole court. The judicial committee is something we cannot find this judicial committee in the civil procedure law, but this judicial committee is actually very powerful organization inside the court. According to the law on the organization of People's Court, courts at all levels set up a judicial committee. The members of judicial committee are nominated by the president for appointment by the People's Congress at the same level. Most likely, the members of the judicial committee are chiefs of each divisions of the court and the president and vice presidents. The judicial committee is responsible for deliberating major or complicated cases. Some notions I want to introduce first. Okay, the judgment-making procedure. Usually after a court trial, the three-judge panel is going to sit down together and deliberate the case. The first step is presiding judge report the case, usually prepare a written case report, and the panel is going to discuss the case because they all participated in the court trial already. And the decision is made unanimous. Unanimous refers to all three judges reach the same opinion. Then this case can go directly to a judgment without being discussed by judicial committee or go reviewed by the chief judge or vice president. Usually the judgment is made. Consensus opinion: if 3 judges, 2 agree and 1 judge does not agree, usually they can still reach a decision and issue the judgment. The third is divided opinions. Divided opinions refers to one judge very firmly insists on a different opinion on this case, and then require that the case reported to the chief judge. Then this case is going to go through the chief judge review, signature by the chief judge, and then the vice president, who is in charge of the civil division, is going to review the same case too. Or if the chief judge or the vice president find this case need to be discussed, it's really split and opinions need to be submitted to the judicial committee for discuss, then this case is going through the judicial committee discussion, which is more complicated and takes longer time. We learned that the judicial committee is responsible for deliberating major complicated cases. So a case result in a divided opinion falls into this category of complicated case and shall be decided by the judicial committee. However, the decision process and the name of the judicial committee members are not going to be mentioned in the judgment. Only the panel members' names are going to be listed there. Many law scholars have been discussing the legitimacy of this practice. So this is something maybe in the future this is going to be changed. We are not sure what the situation is in the future, but this is something that is kind of controversial. After the judgment is made, the court is going to pronounce the judgment and serve the judgment. A judgment includes the name of the panel members and the court clerk with the court stamp. Here I have an example here. We can see here is the 3 names are the name of 3 judges. That's the panel members, and followed by a date, year of the issue, of the date of the judgment issued. And lastly, they have the court clerk's signature and the court stamp. This is a sample of the last page of court judgment. But this judgment is not final. You still have an opportunity to appeal. Time is of the essence for the appeal. The time limit is 15 days after service of the judgment. The appellate court is going to review facts, evidence, application of laws, so almost every aspect of the case. This is also different from a U.S. court where limited cases are going to review the facts, usually evidence, application of law. So Chinese appellate court is really review the facts, the whole facts of the case. Generally, appellate court conduct documentation review. Some cases may go through an open trial, but most cases do not. What kind of decision the appellate court is going to make? Appellate review, there is a time is according to the civil procedure law, appellate review time is 3 months. After the appellate review, the appellate court is going to either affirm the original judgment or amend and issue new judgment. The other choice is remand to the original court for retrial. So those are the 3 possible results of the appellate review. The order of judgment is final after the appellate court affirmed the original judgment. All courts at the trial or appellate court level have a discretionary power to grant retrial. This is something make our court final judgment is not actually final because those court retain the power to grant retrial even after the case is final. Litigants can literally file unlimited number of petitions for retrial. This opens the door to uncertainty, delayed justice, and corruption. This is a problem. This retrial, unlimited numbers of retrial is a problem in this system. But in most situations, the final judgment is final. After receive the final judgment, the last step and the most important step in a court trial system is to enforce the court award. A lawsuit is only halfway done when you receive the judgment. To enforce a judgment and collect monetary award have been notoriously difficult in China for the past 10 years. Here are some facts. Only 14% of the civil judgment is performed voluntarily. More than 80% of the civil cases needs compulsory execution of the court. How this happened? The first reason is the government always favors domestic business over foreign business. Especially those state-owned companies, they are especially protected by the government. In addition, local government protects local companies for local benefits like tax reasons or because they have a special tie or we call 关系 with that company. The last reason and the most commonly happen in small amount lawsuits is lack of laws to curb debtor fraud. What usually happens is you sue your debtor, win the case, but when you apply for the enforcement of the judgment, the debtor disappeared. Chinese saying is that evaporated in the human world. So they just disappeared. This is very common. Many litigants win the case but cannot get their money back. Civil enforcement mechanism. To address the problems in case enforcement, all courts in China established enforcement division from 1997. Enforcement division of the Supreme People's Court began exercising administrative power over lower courts to release lower courts from the interference of local governments. More on civil enforcement. Who is in charge of enforce the judgment? Court of first instance is in charge. Civil enforcement is triggered upon application. Again, this application involves fees. Let me show. Here, the last column is enforcing expenses. We can see the enforcement expenses is almost the same to the court filing fees. So if you pay 1% for the case filing, then again, if you want to enforce the judgment, you need to pay another 1%. So it's totally 2% to pay to the court and 1.5 or 2.5 to the attorney. That's the total expenses. Let's come back here again. The procedure of enforcement is the court is going to send execution notice to the judgment debtor. The court carries out compulsory execution after this notice. The measures for compulsory execution include seal up, destroy, freeze, sell by public auction, or sell off. However, the parties can reconcile and settle during this enforcement process. Here, my comments on this enforcement procedure is it's time-consuming and extremely costly. Even though literally all the expenses like the court enforcing fees shall be paid by the judgment debtor, but after exhausting and costly process of looking for debtor, looking for his property, most creditors cannot find enough sources, enough property to satisfy their judgment debt, let alone the court expenses. When I say it's costly, here are some examples. Expenses on the procedure, the application fee. Expenses on property investigation. That means the enforcement judge is going to travel, sometimes involve travel and conduct the property investigation. And the third is expenses on property appraisal, evaluation, audit, seizure, auction, foreclosure, etc. I want to give you an example. Chinese court cannot sell the property themselves through the court, like government auction. There is no such thing. The court have to give the property to commercial auction companies. The commercial auction company then is going to conduct the auction like all other commercial auction. So the cost is 10%. It's very high percentage. This includes 5% charged to the seller and 5% charged to the buyer. That's totally 10% paid to the auction. So at this point, I want to tell you what is the most important thing during this lawsuit is to do property preservation at the very beginning when you file the lawsuit. So at the same time when you file the lawsuit, when you submitted the complaint to the court and pay the fee, please at the same time apply for property preservation at the same time to avoid this painful enforcement procedure. Before we finish this presentation, I want to give you some online resources that if you are interested, you can find Chinese laws, regulations, or sometimes cases from the website I list. The first one, China Court Organization, is the official website of the Supreme People's Court of People's Republic of China. The second website is the official website of the publication of the Supreme People's Court. The third one, Law Info China, is the largest China law academic research database established by Beijing University. It has both English and Chinese versions, so it's pretty helpful website. The last one is the Law Professor. It's a law blog edited by Professor Donald Clark, who is a law professor with George Washington University Law School. This website has the latest updates on China law, news, legal profession information. For example, if you want to find some kind of law research scholarship regarding China law or law profession recruitment information, you should go to this website. For those who are familiar with legal research in the United States, Westlaw and LexisNexis both launch China law database for research convenience. But you probably know that you have to pay a fee in order to get access to Westlaw and LexisNexis. And that's what I'm going to finish my presentation for today. And thank you very much for attending this session.